They don't get it right all of the time. I don't really deal in a world of fairness. They're gone and they can't testify or participate in the divorce case.
Welcome to Tailored Wealth. I'm your host, Taylor Mavrakos. In my 10 years as a financial advisor, I've noticed that when it comes to finances, women are often considered an afterthought. My intention with this show is to create a space tailored to women as we navigate choices throughout our lives. And here with me today is a family law attorney and good friend, John Thacker from Thacker Law Group. Hi, John.
How are you, Taylor?
I'm doing well, thanks. How are you?
I'm great. Thank you for having me.
Thank you so much for coming on the show.
It's my pleasure.
So we talk just a lot about different phases in life that women go through. And a big one can be the divorce process. I've had a couple of different family law attorneys that we've worked with over the years. And I think it's important to really talk to a few different ones with different perspectives on the process. I'm excited to talk with you today about just your experience in family law. So if you could kind of start out by telling us a little bit about how you got into this business and how that all came about.
I'd be happy to do that. So my name is John Thacker, and I'm the sole partner of Thacker Law Group. So I'm a sole practitioner now. And I practice exclusively in marital and family law, which is not only divorce, but also paternity and related things like custody disputes, business valuations, support-related issues. We deal with all that stuff. And so kind of an interesting story how I got here. I went to college at UF and never really intended to become a lawyer until literally I was a senior in college. And then I sort of realized I wanted to be working with people. And I was always stimulated by, human interactions and everybody you meet in this job is different and their lives are different and their values are different and it keeps things interesting all the time. So when I decided to be a lawyer, I went to law school at Stetson Law. And when I graduated law school, I spent 3 years working for the Pinellas State Attorney as a prosecutor. And my father, Steve Thacker, already had an established family law practice. He never really asked me or pressured me, I should say, to join up with him to do what he was doing. But after 3 years of being a prosecutor, I definitely wanted to try something different. So I joined up with him in 2008, and I was working with him for 16 years. He retired last year. And so now it's just me there doing just family law, which is all I've done since 2008.
Family everything, John. You had a family business, now family law.
Yeah, very, very fortunate. Not everybody has that opportunity. And going in with my dad, who had been doing it for a while, I had the benefit for like the first year or so of kind of following him around and seeing how he did things and seeing how things were different from what I was used to in the criminal sphere. And it was definitely the best possible way of learning, and it definitely kind of gave me a leg up, I felt like, versus just putting up a shingle, so to speak, and trying to figure it all out from scratch, because there's a lot that family law touches on, right? There's real estate issues, there's tax issues, there's all kinds of different issues, and you sort of have to know a little bit about everything to find your way around. I learned a lot from him, so I was very fortunate.
What's your favorite part about your job?
Definitely working with people, and helping people. And that manifests in very different ways depending on the person, because people have different goals. And again, they have different values and different things that they're looking for you to give them help with, and that can mean any number of things. You're dealing with people who you're dealing with their personal lives and the most intimate aspects of people. And the way people engage in their relationships with their spouse and with their children is totally different from one family to the next. No two people, no two families are alike. And so I really enjoy getting to know people and understanding their dynamics so that I can really help them achieve whatever their goals are. And the goals can be very different. Some people don't want a divorce, but they find themselves in that situation because their spouse has elected to move forward. And navigating what their goals are is very different from somebody who, knows what they want, but perhaps their spouse doesn't have any idea that they're seeing a divorce lawyer. And, of course, preserving relationship with their children and making sure that the children's interests are protected is really gratifying too. And frequently in the job, it's a high stress job, as perhaps you can imagine, but there are frequent moments of gratification where you do feel like you've helped someone or helped some children. And when that happens, I try to definitely make a conscious effort to sort of savor the moment, and realize that this is all worth doing, So those are definitely the things I enjoy the most.
I love that. And I think your profession is similar to mine with advising, where people know that everyone is unique, but then they see intimidating fields like mine or like yours, and they think that it's not as custom as they are. They think that when they go to somebody like you or somebody like me, we're going to put them in the box that we put everybody in for this, that, or the other. And it's the same thing in my job, where it's always tailored to the individual client. I don't have even two households that have the exact same financial blueprint. Because to your point, when you think of all the goals that not only just the one person has, but if they have a spouse, if they have kids, if they're a caretaker, if they have all these different people, I think it's really important. And one of the things that I want to stress with this show is making sure people understand that the things that you and I do are really more, I think, like an art or a craft, where you're taking and customizing to the unique situation of every client that you're working with.
I can't agree more with that. I think that's really what makes it our jobs like professional jobs. You really have to approach it with that sort of perspective and sort of custom tailor your services to the people that you're working with. One of the things I tell people, like right when I meet them sometimes the first time, is that, it's never my job to like tell people to get divorced or not. Some people are equivocal or have some conflict about what they want to do. And that's not really my role at all. My role is to, again, identify what their goals are and try to help them get to those goals. And some people want to reconcile with their spouse, and sometimes that happens. And sometimes it doesn't. And if it doesn't, then you gotta, go down a plan B. But yeah, you're totally right. It's just about building a rapport with someone so that you can really learn what it is that they want, that will hopefully give them a service. And you can hopefully identify that really early on in the relationship. And so everyone knows what the goals are that you're working towards. And so sometimes you have to have a conversation with someone where you have to identify what you think you can do for them and what you think you probably can't do for them. And it's really important to do that up front too, so that if they don't think that you can do or meet their goals, then that's understood from the beginning, and maybe they need to see somebody else, and that's perfectly fine. So in family law, it's a very dynamic area of the law. It's a very equity-based area of the law where there's very, very few bright line rules. It's called a court of equity when you go to court. It's not like a criminal court. It's a court of equity. So the judges are empowered with this concept of fairness and equity and reasonableness, and it's these very fluid concepts that can make it difficult to define exactly what might happen in a case. But with experience, and once you understand the law and the facts of the case, you can at least give people some idea of what you think you can do for them.
I love that. And I think it's important to tell people that equity or equitable doesn't mean equal.
Yeah, and that goes to, it's almost like the concept of fairness, right? Mm-hmm. Oftentimes people will meet with me and they say, John, I just want what's fair. I have to give them my little fairness speech.
Can you give it to us?
Sure. I don't really deal in a world of fairness, because that is a very arbitrary concept that sort of varies from person to person. And what's fair to the person that I'm talking to might not be what the law provides or what somebody else or the judge thinks is fair. And when I represent someone, my job is to evaluate the case for them and tell them, again, what I think I can do for them and what I can't. And that evaluation really doesn't have a whole lot to do with the concept of fairness. It has to do with what is the law, meaning what is a judge likely going to do with the facts of this case, and what are the facts of the case. And then once I learn what the facts of the case are, I can tell someone, well, hey, these are what the issues are in your case. Here's your best case scenario, given what I understand the law to be and what I know about your judge, if I happen to know who the judge is on the case. That might be something you can accept, or it might not be, And so if I evaluated it based on fairness, I really wouldn't be giving people a service, because once you're in the sort of legal world, in the family law world, if there's a divorce case going on, there's going to be finality to that case at some point. Either the case is going to be resolved by agreement, which is how most cases get resolved at some point by agreement. And that's what you certainly try to pursue before you go in front of a judge. But if people aren't able to agree to something in the case, then it's ultimately going to be resolved by the judge. And the judge is obligated to follow the law, whatever it says as to whatever the issue is that people are fighting about. The judge is going to do their best to apply the facts to the law. But judges have hundreds of cases each. They have a very limited amount of time. It never feels like enough time when you try a case because you have a day, maybe 2 or 3 days, if you're lucky, to present a history of your family to a judge and have them digest all that information and make a correct ruling. And they try really hard to do that, but they're people too, and they don't get it right all of the time. And the judges will be the first person to tell people that. You know, they do their best, but they're not perfect. And it frequently behooves people to try to be pragmatic and resolve their differences amicably in a way that they can accept, rather than subject themselves to not only the litigation risk of having a judge decide things, but also the additional costs involved of having, you know, a contested trial or something like that. So,
how often in your world does that happen, where they go in front of the judge, and how often do they settle in like a mediation or something prior to?
I'm in court frequently, but it's not always for what we call like a full-blown trial where we're having the judge, you know, decide all of the issues in the case. Sometimes you have some pre-trial hearings that are much shorter in duration, or sometimes you have a judge who maybe just gets involved to deal with a narrow issue in the case because all the other issues have been figured out. I would say that probably over 95% of cases that I handle resolve by agreement at some point during the process. But mediation is certainly a wonderful tool for helping people solve their problems and resolve their differences. For those listeners or watchers who don't know, a mediation is basically a confidential settlement conference where I go with my client, the other party goes with their client, and there's a mediator involved who's usually like a family law attorney. And that person just bounces between the rooms to try to help people reach an agreement. And it's not like Wedding Crashers. I tell this story all the time. If people know that movie, there's a mediation at the beginning of that case where
I
people
forgot about that.
Yeah,
yes.
yeah.
Okay, keep going.
So, and everybody thinks this is how it's going to be until I give this little speech to them. You know, there's this long table and the people are, you know, at the on each side of the table, and they're just arguing and interrupting each other, and the mediator's there pulling their hair out. And I tell people, if that's how family law mediations really were, like no cases would ever settle at mediation, you know, but it's not like that at all. People are separated, and they're usually just with their own legal team in a separate room, and then the other side's in a different room, and you just talk to the mediator all day long, and the mediator conveys offers back and forth and acts as the conduit of communication, so to speak. And it's a great process because when you're at a mediation, you're only there on that one case, you know, and you're not being interrupted by phone calls or emails on other cases, and it really helps you focus on the problems of that case, you know, and there's an immediacy to that really does facilitate and encourage settlement and resolution of problems. And sometimes when you mediate, even if you don't settle the whole case, you've accomplished something by mediating because maybe you've narrowed some issues down to where you know, okay, well, we're in agreement as to issues A and B. Maybe we need some more information as to issue C, and you can get the information and you could settle the case later. So you don't have to settle at mediation. The case can be settled at any point during the case. But oftentimes mediation is a great facilitator of that. So
I totally forgot about that. So if you go to mediation, Vince Vaughn and Owen Wilson will not be there.
No.
And you don't get to yell at your spouse across the table until they interrupt you.
That would be a lot of fun for me to be in that environment. But I'm trying to help the clients that I represent, and I don't think that would probably be an effective way of doing it.
I don't think so. I don't think a lot would get done.
It makes for great television, and that scene in the movie was really entertaining.
Yeah! Shout now! Jump up and shout now!
It's funny, as somebody who does this every day, you see that movie and you're like, oh my goodness, you know, this is what everybody's going to think this is like. And it's not like that at all. So
in the same vein, when people think of a trial for a divorce, is it like a Law and Order episode or like any of these legal, all the court shows? You know what I'm saying?
Yes. Yeah, that's a great question too. I'm glad you asked. In my opinion, the answer is no. And the main reason for that is because I told you that family law deals in courts of equity, right? Mm-hmm. There's no juries in a divorce trial. So it's just being decided by the judge. Okay. And oftentimes, if you have a trial, sometimes you're in a courtroom, but oftentimes you can be in like the judge's chambers or maybe in a smaller courtroom, depending on the judge. It's a little more intimate. It's not like, there's, 30 people typically watching the divorce trial go on. They're usually, it is open to the public technically, which is kind of interesting. Anybody can go and watch a divorce trial if they want to go to the courthouse and there happens to be a trial going on. You can watch and sit there and listen to. Do you
have family members that come and watch it? Not your family members, of the people that are involved. That seems like I'm Greek. That seems like a very Greek thing to do. Like I would have like 500 people at my divorce trial.
Sure. It's certainly permitted unless some of the people in the family might be potential witnesses in the case, in which case they're not able to witness the testimony of other witnesses. They have to be sequestered from other witnesses, but technically that's permitted. I tend to generally think that's usually not a good idea. It just depends on the dynamics that you're dealing with the two spouses, your client, the other spouse, and the other lawyer, and all that kind of stuff. What judge you have. How is the judge going to see if, one side has all their family there and the other person doesn't have anybody there? And is the family going to, make a comment during a bathroom break or something like that? These are the things you kind of have to worry about. Something like that happens. But technically it's permitted. This is all open to the public. So,
John, we should produce a movie called My Big Fat Greek Divorce.
You're onto something here, Taylor.
I think we're onto something here. Can you imagine?
Yeah, we got to get that copyrighted and patented before we.
We can't release this episode till we do all the proper legal. I'm glad you thought of that. I would never have thought of that. That's a good point.
Well, I do have some real world experiences in some Greek divorces because we're so close to Tarpon Springs. So,
for those that don't know, Tarpon Springs is like the Mecca for Greek people in America. My parents live in Tarpon Springs.
And it's very close to here. And I can take inspiration from some of my past experiences, perhaps. That would be fun.
What's the most fun one that you could share?
Okay, there's one that comes to mind now, and I will not name names to protect the guilty here, but it was a young couple, and I think they had only been married for around a year before they got divorced.
Oh no.
And I had the husband in that case. They didn't have any minor children, so we weren't doing a parenting plan for the kids or anything. The families, both sides, they were both Greek families, and both families were really very invested in the divorce, and that's true for both sides. And I understand that, I'm not critical of that. But the case ended up going to trial. And during the trial, we literally were arguing over, it wasn't even really an argument, but a subject of the trial was how we were going to divvy up the unused wedding china, that they just got from the wedding 9 or 10 months earlier, And when you see that sort of stuff, it's a real shame, but I definitely got the feeling in that case that the reason these two folks were litigating with each other was mainly based upon family pressures as opposed to their own individual dislike of each other. I really don't think they had that much animosity with each other, but that was just my assessment. So that's sad to see, but at the end of the day, we weren't able to resolve it, even though we tried, and we ended up having a trial, and the judge ruled. And as far as I know, they're both doing okay. So that's good. I mean, at least we brought some finality to it. And I remember meeting the wife, who was my opposing party on the other side, and having some conversations with her. And she was very likable. They were both very likable people. So that's a memorable one. But that's an example of, getting a sense of the dynamics that you're dealing with not only the parties, but the family members, and really saying, okay, can we get this under control and try to help these people without spending a bunch of money unnecessarily? And that's one that comes to mind.
In our movie, maybe they can fight over baklava or something really crazy.
Yeah, maybe that came up and I'm just not remembering it. I'm sure they were arguing about something besides.
I'm sure it was in there. They're always fighting about that.
Probably.
I did want to ask you too, to kind of go into the theatrics that people think of with a trial. A lot of people will ask, are my kids going to have to go up on the stand and say who they want to live with or what they want? How real is that?
It's extraordinarily rare that children testify in family law cases, whether that's a divorce or a paternity case. It is permitted under limited circumstances, but it requires a procedure where you have to file a motion in advance. The court has to find good cause to do that. In 18 years, I've had it happen a handful of times, probably less than 3 or 4 times.
Wow.
And when it has happened, in cases that I've been involved in, the judge has done what's called an in-camera interview of the child. And that means that the child is brought to the courthouse, meets with the judge in chambers or some sort of informal setting, so that the child doesn't feel a lot of pressure. The child isn't cross-examined by the parents, although I guess that could happen conceivably. But that's the procedure that most judges prefer, especially when you're dealing with very young children, preteen children who are likely to be traumatized, by the courtroom experience or meeting a judge or that sort of stuff. The way that kids typically make their voices heard, and it's not really up to them, of course, but if the preference is there is a portion of the custody statute that permits a court to consider the wishes of a child if the child is of sufficient age and maturity to express a preference. I don't think most judges give a whole lot of weight or credence to that factor, but it is a factor that a court can consider. I would say that in my experience, a child has to be, 15, 16, 17 years old for that to really matter to a judge. And even by then, the judge is probably thinking, why are we doing a custody case? This child's going to age out in 1, 2, or 3 years. And it's a shame to put them through that when they're already that old.
Right.
But there's also a process in family law where you could maybe get a guardian ad litem involved. And a guardian ad litem is sort of a next friend to the child. And what that means is it's typically like another lawyer or perhaps a licensed mental health counselor or a qualified guardian ad litem. This is somebody who meets with the kids, who meets with the parents, can interview people, therapists, school teachers, that sort of stuff, to make recommendations to the court about what's best for these kids in their opinion. So it's like a neutral person who can tell the judge what's going on from their perspective without the biases that are inherent of the parties. It's very difficult for a judge just to hear from 2 parents who are fighting with each other and get an objective view of what's really going on with children. So to answer your question, a guardian ad litem almost always speaks with the children. Okay. And frequently the parties will agree to waive what's called hearsay as to the statements made by the child. So when the guardian ad litem does their report, it will talk about what the kids said about mom and dad and about various things. And the court will consider what the children said to the guardian ad litem by virtue of it being in the guardian ad litem's report. So it's a way of sort of hearing from the kids, so to speak, without requiring them to make a trip to a courthouse and either testify against mom and dad, and or speaking with a judge, which can be intimidating. So,
but the notion some people have that like my kid's 16, so they can tell the judge who they want to live with. It's more complicated than that.
Yeah, I mean, I've certainly represented people who have told me that. Well, my child is going to, say this or that about their father or mother or whatever the case is. And typically when I hear that from a client, I tell them, well, I don't want you saying that to anybody else because if you make me go to a court and say that, oftentimes the first thing the judge is going to say, well, how does your client, Mr. Thacker, know what these kids are going to say about their father or their mother or what have you, And it gives rise to suspicion on the court's part that your client has been manipulating the children or perhaps disparaging or alienating them against the other parent, which is something that courts are very, very sensitive to. So when I hear that, I say, I accept that. I accept, how your 16-year-old feels about it. But if we're going to get into that stuff, we should approach it a different way versus me filing a motion to have them testify.
Do you often recommend guardian ad litems?
Yes, but it only is really necessary where there's a substantial conflict, between the parents as to time sharing issues. Maybe they both have a very different view about what the appropriate amount of time sharing or contact should be. Or maybe they're arguing about decision-making issues where a child should go to school. You can get a guardian involved to investigate, a narrow issue like that. Or a guardian can be helpful if there is danger or abuse or neglect concerns with a child. Perhaps frequently a parent or a client will have fears that their spouse or their husband or their wife is perhaps using alcohol to excess or an alcoholic. And sometimes when you're time sharing, well, all the time when you're time sharing with children, you don't always know what's going on at the spouse's house when the children aren't with you. When the children are with them, you don't know if dad is, passing out on the couch at 6 o'clock at night. And sometimes the children will come back and they'll tell your client, hey, you won't believe what dad did or what mom did. They drank and passed out and slept all day. And sometimes that's true. And that did happen. But sometimes kids, especially young children, will say certain things simply to see how their parent reacts to the thing that they say without it being true. And that's not because the child is manipulative or a bad child. This is a developmental issue, and we all know each other, and we all work together. And with very, very rare exception, we try to help people and try to help children. And the local bar has really made a focus on understanding the dynamics of childhood development and what are called adverse childhood experiences, ACEs, and how divorce can really, literally rewire the mind of a developing child. And so some people want to call me and say, you won't believe what my 4-year-old said their dad did. And I'm like, does your 4-year-old always tell the truth about everything? No 4-year-old does, because they're not capable of it, not because, again, they're bad, but because it's a developmental thing. So as a lawyer, if you have some knowledge or experience or training in that stuff and developmental stages of children, then you can help address that in a manner that's going to be helpful to a judge.
I think that's really, really important information to get out there for people. If they want to hire a guardian ad litem, is that something that's court appointed? Do they pay for that? How do you find one? Would you go through your attorney? How do you do that?
The lawyer is going to take charge of that process. It requires a court order being entered in the divorce case. Typically, it's called like an order appointing a guardian ad litem. And what that order does is it specifies the role of the guardian ad litem. For example, is the guardian going to have, be making recommendations as to an entire parenting plan for the benefit of the child? Or is it going to be more narrowly tailored to, maybe one or two issues that are in dispute? And that same order is going to determine who pays for the guardian. It's a an hourly rate, and sometimes people split that. Sometimes, if one parent makes a lot more money than the other, then that parent will pay a little bit more of the fee. But that's all addressed in that order. And you file a motion to get the judge to enter an order to appoint a guardian ad litem. And oftentimes when you file that motion, very frequently the other lawyer, the other party will agree to the appointment of a guardian, because judges will almost always grant a motion for appointment of a guardian if they think that there's a significant dispute as to parenting issues or some sort of danger issue involving the child.
And I think this is a segue into, I'm going to call it trendy, but a new area of law called collaborative divorce, where it's my understanding, and I'd love your definition on it, but it incorporates a little bit of that like more mental health consideration, trying to make a more cohesive resolution. How would you describe collaborative law?
So collaborative law is a really interesting and new subject. It's been around now, I don't know how, maybe 15 years or thereabouts. I could get that wrong, but I am collaboratively trained, and I've handled collaborative cases. And essentially the way to think about it is a way to resolve a divorce case without having to go to court or having a contested hearing. And it's really taken root here in Florida, and there's many divorce lawyers or family law lawyers who only do collaborative law. I haven't expressly limited myself to that. I still do litigation, but if the right collaborative case comes along, I'll certainly handle that. And the benefit of it is it requires everybody to sort of be committed to the idea that we're not going to go to court, we're not going to litigate with each other, we're not going to do something that hopefully winds up with us hating each other and being able to, unable to co-parent our kids once this is all over with. So the idea is each of us is going to have a lawyer. We're going to have a neutral mental health facilitator involved, typically like a psychologist or a mental health counselor, someone to help them communicate with each other during the process, establish a parenting plan if they have children. And then there's also typically a joint financial expert, like a forensic accountant. And essentially, the idea is we're all going to work together. We're going to exchange documents together. We're going to have a number of meetings together so that we, A, get all the information that we need together to make decisions. And we're going to work to make decisions to resolve the case by agreement once we have that information. And I'm a believer in the process. I also think that it requires the right type of case. If you know at the beginning that your spouse is going to be hiding money or uncooperative with regard to document production, it's not a good collaborative case, in my opinion.
Okay.
You'll just be spending a lot of money unnecessarily.
To that point, because my understanding of collaborative law is if one party wants to then litigate, you have to hire all new lawyers, a whole new team, and then it becomes very expensive. Is that correct?
That's exactly right. So if the collaborative process fails, in other words, they go through it and you're not able to reach an agreement, the lawyers and the professionals who are working in the collaborative process, they're gone and they can't testify or participate in the divorce case. And the idea there being, it's sort of a motivating factor for people to solve their problems and be pragmatic. And it is effective. It's I don't know what the statistic is, but with experienced collaborative law lawyers and collaborative professionals, it is very rare. It is the exception rather than the rule that people don't resolve the case in the collaborative process. It does happen, but again, maybe 1 out of every 10 cases is like that, and maybe even less than that. So especially when, but it takes some work on the front end by the professionals to make sure this is a case that is likely to be effective in the collaborative process. And if you make that determination, then it's probably going to work out. So. And
in that example, is everyone in the same room?
Sometimes. So you probably wouldn't be doing the collaborative process if you were dealing with people who were at each other's throats. You probably wouldn't be in that environment to begin with. It can still be emotional. It can still be stressful, but there's things you can do to ameliorate that. The professionals can speak with each other between the meetings, get ahead of sensitive issues, discuss that with each other, and to where it's rare that is an impediment. Sometimes it is, sometimes you're, doing collaborative meetings over the holidays and, somebody didn't buy someone a Christmas present and they're really upset. I mean, really, it's people are extra sensitive as they go through the process. And sometimes you just got to be a little extra careful about that. But yeah, you can be in the same room, but usually it's at one of the professionals' offices. And these are people who, like maybe the CPA's office or the mental health expert's office. And these are people that both parties agreed, hey, we're going to hire this person together to work for us together. So it's not like you're in a courtroom, and it's not like you're in an antagonistic environment with somebody who has sided with your spouse over you, So building a rapport with people. And truthfully, the lawyers want to build a rapport with both parties also. You're representing your client. You're looking out for them, but it's not going to work unless both parties understand your role and that you're not, out there to trick someone or do something contrary to the spirit of the collaborative process. So
I love that. What is there a type of case that you like the best working on?
So generally, that's a good question. So the type of case that I enjoy the best, I represent a lot of people who are really wonderful people. And they appreciate your work for them and you work hard for them and they say thank you and that sort of stuff. And maybe when their case is over, they'll send you an email or give you a call a year or two later to say, hey, I really appreciate what you did. And things are better now, even though I didn't see it at the time. And that's frequently the story, So I love representing people like that, but not everyone is like that. And I represent people who aren't like that too, and that's okay. And I want the best for them also. But the people who are engaged with you and understand that you're working hard for them and the people who also are really cognizant about what the needs of their kids are, as opposed to, I don't want to say using their kids. That does happen sometimes. in different ways. But, the people who are able to recognize what's really best for kids, sometimes, I'll be representing a dad or something who's works, 60 hours a week, and on the weekends or something. Is that gentleman going to take the position, hey, you know what? I want 50-50 time with my kids. And on my days when I can't pick them up after school, I'll just have them in aftercare for, 3 hours every day. Or is that dad going to say, well, their mom lives a block away from their school. It's better for the kids to just go with their mom where they use, that sort of thing. And the people who are in tune with that and in tune with what is really best for their kids, I really appreciate representing people like that. So,
what's that saying? You have to love your kids more than you hate your ex-spouse.
Oh yeah, I've heard that one before.
I've heard that one before too.
There's another saying that I like because I was in crime before. I was a prosecutor for 3 years. And, very, very true. It says in crime you see bad people at their best, and in family law you see good people at their worst.
Ooh, I like that.
There's nothing truer about that. And it's funny because oftentimes when I was a prosecutor, not to go off on too much of a tangent here, but when you convict someone or you have a trial, fundamentally deep down, most defendants know that they did it. You know what I mean? that
No, John, the jail is full of innocent people.
Right. But there isn't this sense of, I can't believe I was convicted, like the cop testified, they tested the drugs or whatever it is.
It's on camera. They're like, I didn't do it. It wasn't me.
Exactly.
The clone.
But in family law, you do represent people from time to time who take no personal responsibility for their own circumstances. And they blame somebody else. Maybe it's their spouse, maybe it's the spouse's family members. And that's their right to do that. But infrequently, I should say, is there what I call total vindication, reached in a family law case, particularly if you're trying a case. It's very rare that everything goes your way. Just because judges tend to want to split the baby sometimes. They want to say, well, I gave this person what they wanted here, so I'm going to give this person what they want here. And that's sort of human nature. And you see that a lot. And, but sometimes with certain types of people, most people aren't this way. If a judge or somebody else sees it differently than they do, it can be very difficult for them to understand, because people often feel very victimized by their spouse or by the process. And I don't question or quarrel with those feelings, but the family law process can be very, very hard on people. And sometimes it can bring emotional vindication, but a lot of times it doesn't. And because it doesn't, everybody should be motivated to try to problem solve and be pragmatic to some degree. And I try to encourage that where I can, so.
I love that. I think that's great.
Thanks.
And I have a question for you because, families are of all different kinds now. We've got a lot of blended families, and I'm curious for step parents when there's a divorce, and let's say you've been in that child's life since they were a baby. Do step parents have any kind of legal rights or anything like that?
No, unfortunately, not really. So if you're talking about like, if two people get divorced and one of the former spouses remarries, and then they get to, or would they have rights to the child?
Like for example, people get married and I have a family member that's this way. She had a very young son, but she then met a nice guy. They got married. The son was like 2. If they were to get divorced in 10 years, it's like his kid, but it's not biologically his kid. Do step parents have any kind of visitation rights or anything like that?
Not usually, unfortunately.
Not unless they legally adopted them?
Right, exactly.
Okay.
The only other exception to that I can think of is if there was like a dependency proceeding. A dependency proceeding is where the state gets involved when you have an at-risk child or a child who's subject to being abused or neglected if the state doesn't get involved. So sometimes dependency proceedings will get underway if like Child Protective Services comes to a house and they find out, that a parent's not able to care for a child, then the state can initiate a dependency proceeding and the child could be placed with maybe like a step parent or somebody who can be, who everyone's convinced is safe to watch over the child until whatever the parent's issues are addressed. But typically no. And it's a sad situation because I see it frequently where you have a parent who really does have a parent-child relationship with a stepchild, and then they get divorced. And it's really sad sometimes. Sometimes they don't have contact anymore. And that's something that's not only hard on the parent, but, you can imagine how it's hard on the child who's had, this parent figure in their life for so long. And sometimes the child, grows up and they reach the age of 18, which is the emancipating age. And sometimes they reconnect with their step parents, which is a great thing to see. But that's ultimately up to the child, who's now an adult at that point, and that's outside the purview of the court system. So
I'm curious, when you mentioned clients call you years later, people get remarried all the time. How many of your clients call you and ask you for a prenup? And do you do prenups for people? What do you think about prenups? All the things. I want to hear everything you think.
Great question.
Yeah.
Yes, clients do get remarried.
They do.
Sometimes they get remarried to their former spouse that they got divorced from.
Yes, they do.
I saw that happen a couple months ago on a very, very high conflict case that I had
Really?
years ago. And I couldn't believe my ears, but it goes back to the story.
Did you officiate the second wedding?
I did not. I was not involved and I was
Dang
not
it.
consulted, but that's okay. I wish them the best, and I hope
Me
that
too.
that's the end of it.
Me too.
So
Matthew McConaughey's parents got married like 3 times to
Is
each
that
other.
right? I didn't know that.
Yeah,
Okay.
really crazy.
Yeah, and he's over in Texas, right? So they'd be under Texas law over there. But that's funny. I didn't know that. Well, God
He had a
bless
good
them.
biography. It was a wild relationship that they had.
I can imagine 3 times.
3 times, yeah.
Well, hopefully 3rd times was the charm. So yeah, but to answer your question on prenups, yes, I do them.
Okay.
And I gave a speech about prenups to the Clearwater Bar a couple of years ago. I was asked to speak about it. And I put together a little slideshow and all that kind of stuff. And there were judges and other lawyers there.
Are we about to get another John Thacker speech? Because I'm ready for it.
Well, if you're ready, I'm about to give it to you. So the interesting, well, it wasn't interesting, but I think I shocked some of these people by saying I don't really like to do them. And I'll explain why I said that. Prenuptial agreements, as you probably know, it's basically a contract that people enter into that basically says, hey, if we ever get divorced someday, it's all right here. We've got it all figured out in advance. And this is going to save us a ton of time and money because it's all right here. Sometimes that is true. Sometimes a good prenup does save time and money. But when you have a prenuptial agreement, at the very least, you're inserting new issues into the case. And what I mean by that is if you don't have a prenup and you're getting through a divorce, it's like you've got 3 main issues in the case. You got equitable distribution, meaning how are we going to divide up our assets and liabilities that we've accrued during the marriage? We've got support-related issues, meaning child support and alimony. And we've got a parenting plan if you've got kids. Those are the issues. When you have a prenup, there's a number of questions that arise. A, is the prenup valid and enforceable? And there's any number of grounds that somebody can allege to try to set aside a prenup as being invalid or unenforceable. Maybe there was an incomplete or inaccurate financial disclosure before the prenup was signed. Maybe it was signed the day before the wedding when the wife didn't have any choice but to sign it or what have you. So these are some examples of some grounds by which people frequently will attack the validity of a prenuptial agreement. If you cross that hurdle and it's valid, then what does the prenuptial agreement mean? Sometimes you're dealing with prenups that were drafted 20 years ago. Sometimes the law has changed since then. Sometimes the prenup was drafted or signed in a different jurisdiction. Sometimes I had a case once where people had a prenuptial agreement in Alabama. The prenuptial agreement said this is to be interpreted in accord with Alabama law. And every state has different laws as it pertains to family law and divorce. So I know nothing about Alabama law, but I had to find out what Alabama law said by flying to Alabama and speaking with Alabama divorce lawyers to say, what does this prenuptial agreement mean, right? So getting into this, if you have a dispute about what the prenup means or whether it's valid or not, you can add cost and add time and add conflict to a case, right? Now, sometimes you've got to do a prenup. Sometimes you got to do a prenup because you want to protect assets or because you want to do an alimony waiver or something like that, or because you want to make provisions for your spouse and you have to do it and it just is what it is. Sometimes you can do some planning on the front end to accomplish the goals that you were trying to accomplish by doing a prenup without actually doing a prenup. Sometimes I meet with people, John, I need a prenup. Okay, come and see me. And they tell me, well, I inherited a bunch of money from my late father. I've got it sitting, some of it's in an IRA. I inherited his cabin in North Carolina or whatever the case is. And sometimes when I meet people like that, I can say, well, listen, just do this or that with that money. Do this with the cabin, keep it in your own name or what have you. And you really don't need a prenup, because if you go through a divorce and you do those things, those assets will be protected, So
because they're inherited.
Right. And that's, inherited assets can be subject to equitable distribution, or maybe a portion if like the value increased during the marriage. It can be kind of complicated, but you tell people, there's things that people can do depending on what their needs are that will protect them without maybe having to go through the hassle and the expense of doing a prenuptial agreement. So it's a case-by-case thing. You're trying to figure out what people's goals are. Some people say, I want to protect my assets. Some people say, I don't want to pay alimony. Some people say both of those things. And you learn about what their facts are, and you can advise them at that point whether or not you should do a prenup or not. And if the answer is yes, then there's a process involved to do it correctly, or in a way that hopefully will protect them.
You slipped in their alimony waiver. Does that literally mean that somebody can waive their right to ever asking for alimony?
Under certain circumstances, yes.
Okay.
There are some cases though that suggest that what's called temporary alimony can't be waived in a prenuptial agreement. So, for example, oftentimes you'll see a prenup that says, neither party is going to pay alimony to the other party. There are some cases that say that even if you have a prenup that says that, a spouse can be entitled to temporary alimony during the pendency of the divorce proceeding, because sometimes you have a dynamic where perhaps only one spouse earns money and the other spouse makes no money. The court system doesn't want to see that spouse starved out, so to speak, if you don't mind me using that language, from being able to raise meritorious defenses to the prenup because they don't get alimony or they can't afford to put food on the table while they pursue these legal remedies. So yes, you can, under certain circumstances, waive alimony in a prenuptial agreement, but there's exceptions to everything.
So can you ever find yourself in a space where you're not legally married? So if some people say, well, that all scares me, I don't want to get legally married. Is there ever a spot, like people say the term common law all the time, if you're not married legally, can you ever be in a spot where you're in a common law marriage and then you're still, after a certain point of living together or being together or whatever the case may be, where you go through something that feels like a divorce?
That's a great question. Well, the answer is yes. And I'll talk to you a little bit about common law marriage first. Common law marriage is something that's been around since, old England, since like the 1500s or something like that. And it does exist in the United States, but not in Florida. No. So you can't like live with someone and call them your husband or call them your wife and say, well, we're married even though we never did the certificate. In certain other states, you can, they do recognize common law marriage, and Florida will recognize valid marriages from other states. So there have been cases where people have been legally married under the common law in a different state where they get divorced in Florida, and Florida courts will say, well, we're going to, even though we don't do that here, we're going to recognize that that was a valid marriage in this other state.
Interesting.
Right? With that exception aside, I should say, if people are living together here and they want to go, if your question is, would they go through something like a divorce? It really just comes down to A, do they have children together? And B, do they own property together, right? Yeah. If they own property together, then there are certain remedies available to them. Like if they own a house together, you could ask to partition the home, and that's a different type of lawsuit than a divorce case. And that just basically asks the court to require the sale of a jointly titled home. And of course, if they have children together, then you're dealing with like a paternity action where you're dealing with a parenting plan and child support.
Which you do that as well.
Yes, I do.
Question, important question. What happens to pets in a divorce?
That is an important question. There's a case from about 20 years ago that is about the most cold-hearted case you'll ever read.
Oh no,
I'm
nervous.
It was written by a judge who I'm sure was trying to do his best, but people who read this case can't believe what he said. But he says a pet is a piece of chattel, and chattel means like personal property. And the court equates it like a pot or a pan or a dish or a piece of furniture, to be identified by the trial court valued, and distributed in equitable distribution. So what that means legally, if I digest that
I'm
analysis
shocked, but
for
continue.
you,
I'm horrified. Go ahead.
We don't have enforceable like parenting plan or custody type arrangements for pets. The court legally is required to simply value the pet. And when I say value, I'm not talking about emotional value. I'm talking about what is the fair market value of a 8-year-old Cocker Spaniel or whatever it is.
Well, yeah, because if it was emotional, the case would be over. It's priceless.
Right.
Can't put a price on it.
That's right. And the court has to award it to one of the parties. So
will they, like, for example, if you buy a designer dog, if you buy a Frenchie and it's $8,000, do the people produce like that receipt and they say it's valued at $8,000?
it has happened. I represent right now actually a dog breeder. And her husband has taken the position that these dogs that she owns are purebred. I think it's a greyhound, and they're very, very valuable according to him. But according to my client, they really don't have any market value because one of them's got a hip issue or this or that.
Right,
So
because
yes,
she's not going to sell them.
no, and it's difficult for me to imagine that the judge in that case is going to be real excited about putting a big number on her pet dogs. So
Fair enough. I'm rooting for her and her dogs.
Me too. I think it'll be okay.
I think it'll be okay. Okay. I'll ask you a couple of months from now. I'll be like, hey, how'd that whole case shake out?
We'll see.
We'll see. Oh my gosh, that's funny. I wanted to ask you also, if you're not a fan of prenups, I would guess you're probably not a fan of postnups.
I am a fan of prenups and postnups if I think they're going to help people. You know what I mean? And again, it just requires that analysis. And if it needs to be done, then it's great and we'll do it. Postnups are kind of similar. Typically, by the time people are talking about a postnup, there have already been significant marital problems, right? Either, somebody maybe had an affair or there's been a breakdown of trust or on some level or this or that. I try before engaging in doing a postnup to really try to help my client understand whether or not the marriage is really still viable or not. If the answer is, and sometimes they need to see some counseling or do some counseling on their own or do some soul searching of their own to kind of come to that conclusion. Because if the answer is no, that it's not really viable and we're all just kind of kidding ourselves, then it's probably better just to get divorced, But there are circumstances, and I have done them, where people work really hard to reconcile their differences. And sometimes a postnup is one of the stepping stones in the process of rebuilding trust, Okay. I had a case not long ago. I represented a gentleman and he hired me to do a postnup for him. And it actually went very smoothly, There was somebody else in the picture for a while, but they both got together and with some help with counseling, they got on the same page. And my guy basically said, if we're going to try to make this work, I have to have a postnup because I don't want to go through this turmoil again. And we did a postnup. You still have to go through a lot of the steps that you go through with a prenup. Like you still have to do a financial disclosure, Sure. And that process can be somewhat time consuming and expensive depending on how much assets you have, Yeah. If it's not that time consuming if you really don't own anything, but if you have a complicated financial picture, then, you probably want to have an accountant help you with that and do a good financial disclosure and gather some records and that sort of stuff. So yeah, it can help people. And that particular example I gave you, I haven't heard from this gentleman in 2 years. So maybe
it's going well.
Unless he hired somebody else to get divorced, I'd like to think
he would
that maybe
never.
Hey, you're very sweet. But so yeah, I thought that was the type of case that it made sense to do that.
Because the group of women I'm thinking of, so as you know, I'm a certified divorce financial analyst, which has become a very helpful but specific job that I do. If I'm not meeting clients as they're finishing the divorce and just starting as their financial advisor, right? And I'm doing that divorce work and helping with equitable distributions. It's typically women who have been stay-at-home moms. Their kids are about college age. They're getting divorced and they always have a partner that says, we're getting divorced and you're taking my money because you haven't worked for all these years. And they've sacrificed careers and all these different things. The conversation I constantly have is you're not taking anyone's money. It's your money, especially if they have been married for that whole time. But I just always kind of wonder what advice you would give to primarily women, but could also be men who choose in a family dynamic to not be someone that's earning a paycheck and they commit their lives to raising the children, growing the family. What protections or advice would you give those people when they do that?
Great question.
Yeah.
So obviously I meet people, mainly women, in that circumstance all the time. And I have repeated sort of experiences, sometimes when I meet people like that, maybe they've been married 30 years, they haven't worked in 30 years or 20 years or what have you. And oftentimes a woman in that situation will be apologizing to me. John, I'm so sorry. I don't know what my mortgage payment is, or I don't know what my electric bill is. I haven't written a check in 20 years.
Happens to me too.
And they're terribly, I don't know that the word is embarrassed, or they feel ashamed, I think.
They do.
And that comes out almost always at the initial consultation. And I have to slow down, whatever I'm doing and say, listen, there's value to what your role was in this marriage, and the law puts value on it in multiple different ways. And I want to encourage you not to be hard on yourself or feel bad that you don't know these things. It's very typical, and we're going to figure it out one way or the other, even if you don't know all this stuff. It's okay, And what I mean by the law puts value on it, when we're talking about equitable distribution, for example, the default is that the court will evenly divide the marital assets and marital liabilities. The way things are titled, the car is just in his name. It doesn't really matter typically. The question is whether it was purchased during the marriage or not, And again, there's exceptions to everything, but that's the general starting point. So if you have the stay-at-home mom and the career dad who's earned all this money to buy these things, the wife is entitled to half of whatever was purchased during the marriage, to the extent that it still exists as of the date of filing of the divorce case, right? So that's one way. It's you're going to get half of all that because you were he was working and making the money, but you were raising these kids or doing whatever it was that you all agreed together in your marital dynamic to do, and you're not going to be punished for having that role, right? And with regards to alimony is another example. The alimony law is a frequently changing thing. We have a lot of changes in the alimony law, and there's two sides to that argument, and I really don't have a strong feeling one way or the other about, the appropriateness of alimony or this or that. But the state of the law right now is that we have alimony in Florida. We don't have permanent alimony in Florida anymore, but we still have durational alimony. And durational alimony is a form of alimony that can last up to 75% of the length of the marriage in a long-term marriage, which is over 20 years, right? And the reason we have alimony, or at least the logic behind it, is there's no way for a woman in that situation who hasn't worked for 30 years to start a career and ever wind up on the same trajectory as what we call the payor spouse, in this example, the husband, right? It's just never going to happen. Someone in that position could go out and get a job or be re-educated, but depending on their age and their skill set and their work history, sometimes it's just not possible, right? So the logic behind alimony is that it is there to enable both parties to enjoy the marital standard of living post-divorce to the greatest degree possible, right? There's barriers on that at the law.
Sure.
The law says it can't last longer than a certain period of time. It can't be more than a certain differential in their incomes. And oftentimes there's not enough money to go around, right? So sometimes you're dealing with people who can't get by just on the alimony, or, the payor, doesn't have enough to really neither of them can maintain the marital lifestyle all the time. But yeah, we still have it. And that's, to answer your question, one of the ways in which the law recognizes the value of the role of a woman who doesn't have a career oriented role. And interestingly, just as an aside, I started doing family law in 2008. And back then I would see alimony cases all the time. Permanent alimony. And you still see alimony cases, but there's been a cultural shift. You have, I represent far more career-oriented women than I did even 15 years ago. And I can't say that that's, that my sample size is representative of the public, but the court's attitude towards alimony has changed too. Courts are readily wanting to impute income to a wife, even if it's just like minimum wage income. If they're capable of earning something, the courts are very, very likely to want to say, well, hey, I'm going to impute some amount of income based upon what they're doing, and it's going to contribute to whatever their needs are. So it's been interesting to see, because perhaps more than in any of the other divorce-related issues, the issue of alimony has been quite in flux over the past 15 years. And I don't think that's going to change,
It's interesting because the more people that I talk to and ask that question to and kind of identify that specific client, I see a lot. I think initially when I would ask attorneys, I was looking for some kind of legal protections. But what I am realizing more and more is that I think the solution to helping those women is more so that a lot of it is just inflammatory language that they're hearing from their partner that's not substantiated by the law. Because what I keep hearing is, Taylor, we do have those protections in place. And it's a matter of saying when your spouse says something jarring, like you're taking my money or you're not going to get any of this money, it's not substantiated by anything. So just maybe what helps is shows like this, where you get the word out that that's not true and that you have those protections, as opposed to there's some secret sauce that nobody thought of for how to protect these women.
Well, what I tell women that I meet who hear that from their spouse is, I hope your husband hires a competent family law lawyer, because a competent family law lawyer will tell your husband that you're going to get half and she's going to get half. And the more time you spend fighting about it, the more money you're going to spend unnecessarily. Again, I'm painting with broad strokes here, but equitable distribution is typically 50-50. And if you have somebody, and I've been up against people like this, Taylor, who cannot understand how their wife is entitled to half of the estate. And if they don't get off of that idea, you just try the case and you go in front of a judge and say, Judge, I'm so sorry we're here wasting your time today, but this gentleman doesn't understand the concept that we're dividing the marital estate in half. And you serve your client that way if you have somebody who's really that obstinate on the other side of the case. But if that person who's perhaps a little hard-headed and perhaps is used to controlling or manipulating his spouse gets to a competent lawyer, then that person hopefully can actively engage him to solve problems and avoid all that nonsense, because ultimately it's just a waste of time and money in many cases. So
whether it's a YouTube short or they want an Avatar-length 4-hour movie, you know how the movie's going to end, pretty much. And it costs a lot more to make Avatar than it does to make a YouTube short.
It's true. At the end of the day, and I tell my clients this too, I cannot control the decisions that your spouse makes, or that their lawyer makes, and neither can you. So we shouldn't spend that much time or energy pulling our hair out if they're going to be taking a crazy position about something, There's ways to get the case resolved favorably for you, regardless of what it is they're doing or the decisions that they're making, because people often feel like, oh, I got to get him to understand, or, he's arguing saying I'm going to get nothing of this or that. And it's like, we're going to start now on tuning that stuff out. You know what I mean? He's a big boy. He can make decisions on his own. He's got a great lawyer, and we're either going to work it out within the confines of what the law provides for you, or we're not, and we're going to have a trial and we'll get it for you that way.
We're going to wrap on this. Do you know what I tell them?
What's that?
I say, if your husband is that much better at business than you, then he should understand that he signed a contract when he married you.
Yeah.
It's a contract. Yeah. So if he's good at business, then he should be able to understand the contract that he signed.
I'll be sure. I'll bring you in to have a talking with these people, Taylor. I think that's words of wisdom,
Words of wisdom. Well, we've got a movie to make, John.
I'm ready.
We're ready to go.
Where's the baklava? Let's do it.
Let's do it. We'll toast over some ouzo.
We got to get some families in to fight over it.
I love it.
We'll just make a little small pan of it and bring like 20
when you
people
said
in.
that, I just saw a visual of my entire family just like flooding a courtroom, and I got anxiety. I'm like, you're good. You're not even married yet. You're fine. It's okay. John, you are such a delight. Where can people find you?
My practice is in downtown Clearwater.
Okay.
I've got a website. It's www.thackerlawgroup.com. You can go to the website, get a little information about me. My contact information is on the website, and my phone number for my office is 727-446-0525.
Well, I can't thank you enough for coming on today and for all that you do and for how funny you are.
Oh, well, you're funny.
This has been a delight.
It's been a delight. Thanks for having me, Taylor.
Thanks so much. Fun. Awesome. And thank you all for tuning in. And until next time, remember that your wealth suits you better when it's tailored. High five.
Let's do it.
That was awesome.